Admission. We had three sessions on admission starting from section 17, 18 and 1920 together. Now, in most of these discussions, I have told that admissions are always against the person who is making them. But is that all? Can there be any exceptions where admission is made in favor of the person who is making it? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we were discussing on chapter 2, which is all about relevancy of facts, covering from section 5 to 55. Here in this video, I am going to give all focus on section 21, which is all about proof of evidence. We are going to understand this section, then with the help of the chart, then we are discussing the illustration, and finally few case laws. Not wasting any of your time, let's get into the first slide. Here in this slide, let us try understand the legal language of section 21, and though if it looks little tricky here, in my next slide I have a complete chart covering section 21. To that extent, you need not to worry. Section 21 is about proof of admission against person making them and by or on their behalf. The section says admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest except in the following cases. Basically, what does it say? Admissions can be made against the person who is making them or the interested parties who are making them, and it is on a general circumstances cannot be made in the favor of the party which is making them or any of such interested parties. However, there are three exceptions given here. So basically under section 21, the admission is not only against the party which is making it, but it can be also to the beneficial of the party which is making it under three different circumstances. That is why the second part of the section says and by or on their behalf. Now what are the three circumstances? Subclause 1 says an admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead, it would be relevant as between third persons under section 32. Now the person is dead. That is the first scenario. Subclause 2 is on an admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body relevant or in issue made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. Looks like a lot of English, but nothing to worry. In my next slide, I will explain in detail on this. Basically, three important words here you need to remember under subclause 2 are the state of mind, 1, the state of body, 2, and either state of mind or body accompanied by any conduct. That can also stay as an exemption, which I am going to explain in my next slide with illustration. And the third and the last exemption here is an admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. For this also I have an illustration in my next slide. Finally, before we go to any further, we also need to remember that section 32 plays certain amount of role under section 21. That is, section 32 subclause 1 and 2 are referred here. Section 32 is all about cases in which statement of relevant fact by person who is dead or cannot be found etc. is relevant. That is what section 32 discusses, and here under section 21 we are referring to subclauses from section 32, that is subclause 1 which is on when it relates to cause of death, and subsection 2 or subclause 2 discusses about made in course of business. These two are referred. One already has come under section 21 subclause 1. The other one is referred in an illustration. There I will bring the light on this particular aspects. But now let's move to the chart which gives complete picture on section 21. Why to waste time? Let's log in there. Here comes the chart. We have read lot of theory in my previous slide, and if you are unable to understand that legal language, this chart will clarify everything very easily. First thing first, look at that title of section 21. It has three major parts if you ask me. In the first part, it says proof of admissions. Secondly, it says against persons making them, and then by or on their behalf. So if I have to divide it into three parts, first I will keep proof of admission as a main heading, under which there are two types. One, against person making them or the self-harming admissions, and the second type is by or on their behalf, which means self-serving admissions. Let us continue the discussion with the help of these two types of admission. First thing first, the self-harming admissions. What are self-harming admissions? These are the admissions which are made by a person to whom such admissions are going to cause loss, or maybe it is going to cause cost to his representatives who have interest in that particular subject matter. Anything making such an impact are known as self-harming admissions. And self-harming admissions are most relevant admissions, and you might ask me why so? Because the general assumption is that no one would like to harm himself or his beloved or interested people. Now, the only thing that you need to observe in the chart is those two yellow boxes with red outlines. These are the assumptions that I have added. They are not spoken very clearly or in black and white in the section, so I have kept them in yellow box. Rest of the things, everything is covered under the section itself. Now, only thing that we need to remember when it comes to self-harming or the admissions which are made against the person who is making them, they are relevant admission just because it is a general assumption that no one would harm themselves or the people who belong to them or interested people. That is with self-harming admissions. The second type is self-serving admissions. This is one of the most common admission. Anybody standing in the court will make admission in favor to them. They say, have you done murder? The party will say, no, I have not done murder. Or if the court asks, is this property belongs to you? The party says, yes, it belongs to me. Those are self-serving admissions. Now, nobody would avoid making such admissions. Everybody will try to make an admission which is beneficial to them or to their representatives who have interest in such subject matter. And they are not relevant admissions in a normal scenario. Why? Because it is common among people that they make admission for their benefit. So that is why they are mostly not relevant. Why does I am stressing that word mostly? It was nowhere till now. From where it is started coming? It started coming from section 21 because section 21 gives three exceptions for this understanding, and here are the three exceptions. Subclause 1 discusses about those persons who have made admission and now they are not available. That means the person is dead. Or if there is a clear presence of state of mind or state of body which has subsequent conduct to prove that such admissions shall be admitted as discussed under subclause 2, or if there are anything which are relevant to admission. Now, these three things will protect the person in self-admission also, which is favorable to him or the representatives who have interest in such admissions or such subject matter. Now let us try understand one by one what are these three exceptions, starting with such person is dead. Now to explain this, I will take the help of an illustration of the captain of a ship. For that, we will go to that slide. We need to focus on illustration B, which discusses about A, the captain of a ship, is tried for casting her away. Who is this her here? Her means the ship. Now A is the captain of a particular ship and he has the responsibility of taking such ship in a certain navigation. Like there was a clear route which he was supposed to follow. And the case is on that particular day he has not taken the ship in the regular route. But on the other hand, A has an evidence. What is that evidence? He would keep a book where he will mention on daily basis that how exactly he is taking that particular ship. And on that particular day also, he very clearly mentioned in the book that he has taken the ship in the regular way. Now, in an ordinary course of his business, he has mentioned it every day, every time. Now here comes section 32 subclause 2. What does section 32 discuss about? Section 32 discuss about the statements made by dead persons or those persons who are not available or missing. Now here in this case, if A is dead or if he is missing, now whatever he has mentioned in the book would be relevant, because in an ordinary course of business, that is what subclause 2 of 32 discusses about, which is ordinary course of business. And if in his ordinary course of business he has mentioned on daily basis in that particular book that how exactly he has taken the ship, in that case that book becomes relevant. And if he has mentioned that on that particular day he has taken the ship in the same route, then that is a valid admission even if he is dead. That is what we need to understand from the illustration B. Now let's go back to the chart. The second part is state of mind or body and subsequent conduct. Now here I am taking an example of a gift deed. Now imagine Mr. A has done a gift deed to Mr. X. Now after few days, A says that he was not keeping well when he has done such gift deed. He might say that my mental status was not sound. And then he gives the proof that he was under medication. He gives the prescription by the doctor. He also gives the bill of buying the medicines. Now if he can prove that if his state of mind or body was not good, and on that basis if he has conducted an act of gifting such things, in that case that becomes relevant and that will be considered as an right admission, though it is making favor to the person who is making such admission, because it is indicating the state of mind or body along with the conduct. It will be considered as a valid admission. What is the conduct here? He has gifted. Now gifting is a conduct here. And what is the state of mind or body? The illness in mind or body is the state of mind or body. That is how we need to see exception 2, which is the subclause 2 of section 21. The third subclause of section 21 discusses about any other relevant aspects which are part of admission. Now here we can refer the case law of Ram Bharos and others versus Diwan Rameshwar Prasad Singh. Here what happened? A person gifted a property to another, but in his will he mentioned that such gifted property is fictitious. Here the statement made there in the will is considered as relevant admission. That is what we need to remember. Now let us move to the 5 illustrations and then I will take you to the last slide where we will discuss the case laws. 5 illustrations are there. We have already discussed illustration B. Let us discuss A, C, D and E. Start with A. In the first illustration, there are two parties A and B and they have a document. And the argument here is one party is saying that the document is forged, whereas the other party is saying that the document is not forged. Now here, if A is saying that if the document is genuine and if it is favorable admission to him, then that is not a relevant admission. Likewise, if B is saying that this document is forged and if it is making benefit to B by doing so, then that is not considered as a valid admission. I hope that's very clear. That's all about illustration A. Illustration C is a classic example for plea of alibi, which we have already discussed, where there was a crime and the person accused here, Mr. A, says that he was not there in the crime spot, he was somewhere else. Now, if he is producing evidence for the same, then his admission is relevant, because if he were dead, all the evidences that he had and submitted will become relevant under section 32 clause 2. Now, section 32 clause 1 and 2 are becoming the most relevant part under section 21 also. So, while discussing or once after we discussing section 32, you can very clearly see what exactly we discussed under section 21. Here what happens, if the person is dead or missing as under section 32, then the evidences whichever is given will be considered as admission, because if the person was not dead or missing, he would have come and proved the facts. That is how court assumes. With that, I am going to illustration D. Illustration D is about receiving stolen goods and A is the accused here. What happens normally when someone receives stolen goods? They try to sell it as early as possible, and to achieve the same, they try to sell it for a lower price. But here A proves that he has not agreed, or when someone asks for lower price, he even refused to sell them for lower price. That way he neither had guilty mind nor he had any such conduct which was proving that he had guilty mind. That way, this is a very clear illustration where section 21 subclause 2 comes into picture. The last illustration where we are discussing the case of fraudulently having possession of counterfeit coin, and here A is the accused. But A in the contrary says that he has taken such counterfeit coins, whatever is the facts in issue, he has taken such currency to a skillful person who has examined such coins and beyond any doubt said that it is not a counterfeit coin. Now, whatever A has done, that is taking such currency to skillful person, examining it, all of them are relevant. That way, this will sit classically under subclause 3 of section 21. Coming to the case laws, the first case law that I am discussing here is Salil Kumar Roy versus Babu Den Bhansali. The common understanding is when a statement is made or when an admission is made, it should be either in favor or in against. Now, if it doesn't make any favor or against, such statements will not be considered as admission. That is what discussed here by saying submission of a letter not containing anything either in favor or against, but simply a statement of original defendant, then such letter cannot be taken as that of a substituted defendant confronting with admissions. That is what held here. The second case law, that is Bheru Singh versus State of Rajasthan, is one of the most important or landmark case law as far as section 8, section 21 and section 24 to 30 along with section 25 of the Evidence Act, because all of them are discussed here. The fact is, Bheru Singh murdered his wife and 5 other children thinking that they are not his children or his wife was in an illegal relationship, and then after the murder he came to police station along with the murder weapon. Now he said he killed all the 6 of them. What is that? That is confession. Where are we discussing confession? From section 24 to 30. But why are we discussing that under section 21? It was in this judgment told that if there are any facts which are non-confessional in nature, in that case it would also be relevant under section 21. Whatever is confessed will cover under section 25 etc. But if there are any facts which are not confessed, in that case they will become relevant under section 21. Section 8, which is discussing about conduct, that is also covered in this case law. I hope you remember my class on section 8 where we have discussed about motive, conduct etc. That is also referred in this particular case law. The last case law, that is Ram Bharose and others versus Diwan Rameshwar Prasad Singh, we have already discussed, where an will was made, and in the will it was mentioned that the gift earlier made was a fictitious property. In that case, such statement made in the will, that is the property was fictitious, will become relevant, which is what discussed in the third case law. That's my time on section 21 of Evidence Act, which is all about proof of evidence. See you in my next class with section 22. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.